Welcome everyone to today's CSIA Webinar Wednesday series. My name is Colin Hammond and I will be your host today. From its start, CSIA was built on the principle of collaboration and with the goal to advance the industry of control system integration. In times of crisis, our members have turned to the CSIA community as a trusted source for advice and inspiration. In line with this, we have begun this Wednesday webinar series. Our goal is to help our community manage, survive, and hopefully thrive from the current crisis. We plan to cover a wide range of topics on coping and or leveraging the current situation and have SIs, vendor partners, and special guests present. For those of you who are unfamiliar with CSIA, we are a global nonprofit professional association with over 500 member companies in 40 countries. Our mission is to advance the practice of control system integration to benefit our members and their clients. Our vision is to ensure that manufacturing and process industries everywhere have access to low risk, safe, and successful application of automation technology. CSIA membership offers members access to resources needed to attain and exceed business goals. To highlight just a few of our many member benefits, the CSIA Best Practices Manual guides control system integration companies in the setup and running of a solid company. CSIA's Business Insurance Program offers members an excellent insurance program for business owners, subcontractors, and more. The program includes members from all over the world enjoying the peace of mind that comes with CSIA insurance. Clients in all industries are now seeking integrators with the CSIA certification alongside ISO. They recognize CSIA certified integrators' commitment to industry standards and business acumen. As a result, being certified can shorten the sales cycle. CSIA Industrial Automation Exchange is the premier automation guide featuring system integrators and suppliers who provide industrial, manufacturing, and process automation solutions. For integrators, it's a place to market their expertise. Clients will find white papers, case studies, capabilities, contact information, and engage in conversation directly with CSIA members. Please follow CSIA's online events calendars for all upcoming webinars, including both partner and business webinars. CSIA's business webinars feature topics handpicked by CSIA leadership to help you run your business. CSIA's partner webinars are opportunities given to CSIA's industry partners to address hot topics and demonstrate their expertise. You won't want to miss these opportunities to learn from the comfort of your own office or home. And for more information about CSIA, please visit our website or contact us at info@staff.controlsys.org or 847-686-2245. And at this time, I would like to introduce our presenter, Gloria Forbes. Gloria Forbes is the program manager for the CSIA and ISA program, executive vice president at ECBM for 25 years, and currently COO managing the commercial and professional liability insurance team, specialist in complex insurance risk and coverage forms. And with that, I will now turn it over to our presenter. Welcome, Gloria.
Welcome, and welcome to everyone this morning. Oops, here we go, sorry. So ECBM is an independent insurance broker and risk management consulting firm. We've been in business for over 50 years, and as Colin mentioned, we're the program broker for both the CSIA and the ISA program, and we insure over 190 integrators. Today, what we're going to talk about is the impact that COVID-19 has had on employers. will focus on workers' compensation, employment practices, cyber, and beyond. So let's start with workers' compensation. Most importantly is to remember workers' compensation is regulated at the state level. So while there's a lot of similarity in those acts from state to state, predominantly they all cover medical care and they all cover wage laws, every state executes those a little differently. What is common is that they all apply to occupational injury and disease. Their focus is to cover accidents or illnesses that are within the scope of employment. So they're looking for conditions specific to employment. In situations where your occupational and non-occupational exposure is virtually the same, it's likely that a claim would not be compensable.
Hey, Gloria, I hate to cut you off real quick.
Yes.
The screen is not shared if you had the PowerPoint up.
Oh, yes. Sorry.
I just wanted to let you know. I wasn't sure.
Okay. Let me go back in and do that again.
Sorry about that.
That's okay. That's my mistake there. I thought I'd hit the button. So I will go from the current slide. We'll start from this one, from the current slide. There we go. Are we good now?
Perfect.
Okay, sorry.
Yep. Thank you, Gloria.
Yes. You can tell I'm not an integrator. I'm my technology challenge. So, any rate, basically one of the things that happened from the very beginning when COVID struck, insurance carriers were quick to point out that in a lot of situations, workers' compensation was not likely to respond to a COVID claim if someone were to say that they contracted the disease at work. Why? Because they were just as likely to contract the disease outside of work as they were in work. Now, the states were very concerned about first responders and healthcare providers, and so little by little, they moved to protect those people. But then there was concern about essential workers. We all saw all of the news articles about what was happening in meatpacking plants and the allegation that the meatpacking plants were not working and providing a safe workplace for their employees. Some of them shut down, and then they were later made essential, which drove those people back to work in those conditions. So there was a call to expand the concept of specific to employment to all essential workers. As a result, we have seen a lot of presumptive legislation and orders. Okay, so what is a presumptive order? Well, in the usual situation of a workers' compensation claim, an employee will assert a claim saying that they were injured at the workplace. That claim goes into an insurance carrier, and that carrier will make a determination as to whether that was a work-related claim or the claim arose outside of the scope of work. It's up to the employee to prove it took place in the course of their employment. When you have a presumptive order, it changes the burden of proof. And that's a large issue, because instead of the employee now having to actually prove to the insurance company that they contracted the disease at work, the carrier now has to prove that the employee did not. So a presumptive order basically changes that proof of burden to the insurance company instead of the injured employee. So as we say, California is not surprisingly the most aggressive state to come out with an order, and they did it by executive order. And they recently published this executive order that stated that if you worked subsequently to March 19th, even one day, and you were at your place of employment at your employer's direction, and within 14 days of that event, you test positive, then we are going to assume that your injury, that your illness, that you contracted COVID at your place of employment, and it would be considered a workers' compensation claim. Now, most states haven't quite gone that far. By the way, the California order applies to all employees. The other states have actually passed similar guidance under workers' compensation for first responders and for healthcare workers. And they basically have provided a presumptive but rebuttable concept. And so in that situation, we are to presume that the injury took place at work if you are a healthcare worker or a first responder. But if a carrier believes that it is unlikely that you contracted the disease at work and they want to go ahead and try to prove that you contracted the disease outside of work, then they can rebut the claim. We don't expect to see a lot of that, but it is possible. So as of, I would say Monday, this is a list of the states that have moved to put through a presumptive but rebuttable order. So in the other states, of course, the employee now has the burden of proving that they contracted COVID from their workplace. So often our clients will ask us, well, if an employee comes to us and asks to file a claim, but we do not believe that they really contracted it here, do we have to allow them to file that? And the answer to that question is yes. If an employee approaches you and wants to file a workers' compensation claim for benefits, you are required to give them the information, and they are allowed to file that claim. It will be up to the insurance company to determine whether or not they feel that it is compensable. So what additional liabilities might arise from this situation? So workers' compensation is a sole remedy concept. In exchange for receiving benefits immediately, wage loss and medical bills paid, an employee exchanges their right to sue their employer. So it is unlikely that you will be exposed to any additional liability to your employees beyond workers' compensation. The only exception to that is there are a few states that allow an employee to file claims if they can prove gross negligence. Now, the standards for that are really high. So we rarely see any kind of gross negligent acts against employers. You might, though, see under COVID, COVID might provide a platform for this in those cases where the meatpacking industry is involved, where a number of employees might gather together in a class action and allege gross negligence. I don't expect those are going to go very far, but we are starting to see some action in that area. Otherwise, I would not be concerned about seeing direct claims from employees against you. Independent contractors, though, create a different exposure. So they might be working in your facility. And one thing that we know is that when people have an economic loss, they are more likely to file a claim than at any other time. And so an independent contractor might try to assert that they were an employee to gain workers' compensation benefits. So if they did do something like that and assert employee status, try to assert employee status, your workers' compensation policy would act to defend you in that situation. If they were found to be an employee, the workers' compensation would provide benefits. Now, if the independent contractor is not an employee and doesn't try to change their status, you could still be responsible for them if for injuries that they might sustain, an illness that they might sustain at your location or at a project location. And in that situation, your general liability policy, as long as it does not have a disease exclusion on it, would respond and cover you in that event. So two other areas where you might be exposed to additional risk from claims that might not necessarily happen outside of something like COVID is actions brought by family members against the company, your company, because they were exposed by employment. One of your employees contracts COVID, the family members believe that they contracted COVID along with that person arising out of his employment or her employment, and therefore they bring an action against you. Those claims are covered under the employer's liability section of your workers' compensation. You will also could expose members of the public if you have a positive employee that is working at a customer site or on a project, and they expose employees of your customer, let's say, to COVID, those people could bring an action against you. And again, your general liability without a disease exclusion would respond to those additional liabilities. So mitigation, obviously, a lot of what we're doing under the CDC guidance is to promote safety and the well-being of our employees, but it's also a mitigation effort in the area of defense and to reduce the likelihood of claim or to reduce the ultimate cost of claim. And, you know, we see these words guidance everywhere. No one is saying this is exactly what you have to do. Everyone, whether it's a state provision or a local provision, or it's the CDC provides guidance. And sometimes that complicates the matter. So obviously remote working wherever we can is a mitigation event, but social distancing within the workplace, increased sanitation is required from most organizations. Promoting hygiene practices, you know, suddenly you're told to wash your hands more time in the last 3 months than your mother told you for the first 18 years of your life. There will be posters everywhere reminding people about hygiene practices. Modified travel and commuting, face coverings in all common areas of your facility. They are putting out guidance on improved air filtration and ventilation systems. And then in addition to that, we have procedures to check for signs and symptoms. And that includes temperature checking in some locations, encouraging people to stay home if they're sick, consulting with local health authorities in the event that you do have a case, and training employees in all safety and actions. You know, one of the things that a lot of people don't realize is that if you have an employee and they come down with case of COVID, you are to report it to your local health authorities. You should not be sharing with other employees that someone contracted COVID. That is up to the health authorities to do that contact tracing afterwards. So in the event of all of this, there is some positive that comes out, and that is you may be paying less for your workers' compensation. So most people realize or know that their workers' compensation is dependent upon two things. One, their classification, so that's a reflection of the hazard of what your business is. And the other is the amount of payroll that you have in that classification. There is an organization called the National Council of Compensation Insurance. That's what the NCCI is up there. And they are the rate and policy organization for most states in the country. And remember, I said that every state their law works just a little differently. So the NCCI will provide guidance to the state on what they feel are changes or rules that should be adopted. So these are three of the changes that are proposed currently, and we expect that all states are going to accept them. First is we do have employees that are getting paid but not working. So if you have an employee that you're paying, but they're not actually working, then the guidance suggests that that payroll be isolated and there be no premium charge for that payroll. We may have, with PPP and some of the other situations that are out there, we have people that have been, these are not people that are remote working. These are people that are getting paid but not working. So, we get the opportunity to isolate that payroll and not be charged any premium on it. The second is you may have employees that were performing less hazardous tasks. So in a lot of our situations, we have engineers, or we're using the programming class, or we're using the office class, and a lot of those classes have a much lower rate than the assembly or the electrical installation rates may have those classifications. And in some businesses, because the engineers are working side by side with the assembly and people constructing panels, those engineers might get put into the higher classification. Well, now if they're working remotely, they're working as an office employee. And so in that situation, you would want to make sure that, again, you isolate that payroll, because the suggestion to the states is that payroll be run at the lower classification and the lower rate, so that you would pay less for that employee because their exposure changed. And then the third is the CARES Act actually made available paid sick leave to employees. I believe it's 2 weeks. And so the request there and the filing is to exclude paid sick leave from the calculation of payroll for an individual employee. So we covered a lot with workers' compensation. I don't know if we want to address questions at this point.
So I don't see any yet.
Okay.
Would you like me to let you know when they come in, or do you want to just do them after?
Well, you can do them after.
Okay.
That'll be fine.
Okay.
Okay. So the next area of concern or additional or increased liability that employers are saying comes in the form of employment practices claims. So not everyone has an employment practices liability policy. These policies address those common exposures that an employer has from things like discrimination, harassment, wrongful termination, or bad hiring practices. And so we are seeing, again, increased activity in the employment practices area from COVID-19. Obviously, the challenges that have occurred as a result of the economic slowdown and also from stay-at-home orders, puts an economic strain on employees and on all businesses. And so whenever those things happen, you're more likely to see increased litigation in the area of discrimination or wrongful termination. So we know that there have been, there's been millions of people, but there have been so many people that have been terminated, laid off, furloughed from their positions. And in the practice of doing that, if it is not done very evenly and in a very fair manner, you can spark disability claims. And so sometimes these disability claims come out, from a well-meaning effort. We have employees that are 65 and over. Well, 65 and over is one of those magic COVID guidelines where, the likelihood of a serious injury or hospitalization or death from the disease increases dramatically. And so in an effort to say, well, we want to treat those people, we want to make sure that we isolate those people and they're not exposed, you can be accused of discriminating on an age basis against those employees. You could have the same situation on a disability basis, trying to prevent or keep employees that have a lot of the comorbidities that contribute to serious COVID symptoms away from the workplace as well. So it is really important to watch when we're doing a layoff or we're terminating, because we're not going to ever bring the staff back in any near fashion. The people that you're doing and the decisions that you make in that process can create a lot of litigation, and it's very important to be thoughtful in that. Wrongful termination, obviously we're talking to some extent wrongful termination from discrimination, but people could allege that they were wrongfully terminated because they didn't have the opportunity or the equipment or access to equipment, and so therefore they were wrongfully terminated. They could allege wrongful termination from retaliation. So retaliation is a termination event, but specific to retaliating against an employee because they did something that the employer did not like, and particularly in areas where it's protected. An employee might bring OSHA in because they feel that your workplace is unsafe, and if they were terminated or they felt they were terminated as a result of that, you could have a employment practices claim be brought against you. We'll also see things like that where employees might make a fuss or talk to anyone that they can, or publish on social media that your workplace does not provide safety or protective equipment, or things of that sort. And if they were terminated afterwards, they might allege retaliation. So we have claims that come from OSHA, whose guidance is not very specific in this regard, but what falls under OSHA is your responsibility to provide a reasonable, safe workplace. And so you could be faced with fines for failing to comply in that area. We have Family Medical Leave Act, and then we have the Family First CARES Act. And so you could have liability being increased in those areas. Wage and hour. Wage and hour claims arise out of violations of the Fair Labor Standards Act. And they focus on claims related to paying a fair wage, overtime, classifications, which might be people are exempt or not exempt. There isn't truly insurance coverage for wage and hour claims, even under an employment practices policy. Most employment practices policy might give you a very small limit to defend yourself against wage and hour claims, but they don't actually cover any settlements that might arise from the wage and hour situation. But the only place that you will see people buying wage and hour coverage is large employers with thousands of hourly employees, such as hotel chains, restaurant chains, things of that sort, because typically wage and hour claims become class action claims. The coverage is extremely expensive. The deductibles are very high. So it's very important as a business for you to be aware of what the responsibilities are under the Fair Labor Standards Act and adhere to them. Where we see increase here is people are working from home. They might actually fall into an hourly classification, but their employer has them in an exempt classification. And particularly as they're working remote, people are working additional hours, and it's possible that you could see wage and hour claims coming from that. And then finally, you have as employers, you have a lot of confidential information in your files. And if you accidentally disclose confidential information, you could end up with a privacy claim stemming from employment issues. So what do we do as employees are returning? Well, it becomes very important to develop a return to work plan that contemplates federal and local guidance. Now, we are a firm of 100 people, and most of our employees work, not all of them, but most of our employees work out of our Media, Pennsylvania office. That's suburban Philadelphia. We have the federal guidelines, which is mostly related to the CDC guidelines. We have the state public health guidelines that we have to follow. And then we have local guidelines that are in place. And we have a task force working on that return to work program plan that we have to write. And it's pages and pages. And worse, it changes weekly, because if you read the CDC guidelines this week and compared them to the CDC guidelines 2 weeks ago, they're dramatically different. And so it becomes important for this to be a very well thought out and live, living document so that it can be modified as needed. Whenever you are beginning to recall employees back, rehiring, or putting out new job offers, it's always important to make sure that you're in a compliance mode, and we suggest consulting your legal consultants so that you know that you are doing the right thing. Make sure your policies are executed in a fair and equal manner, and that frontline managers are well informed. So the frontline managers are the people that actually speak to your employees, and often they don't have enough information to communicate properly. So that becomes a very critical thing. Make sure your frontline managers are well informed. And maintain confidentiality of medical related information. So we point this out right now, as a lot of people are talking about how do I bring my employees back to my workplace, and how do I live within CDC guidance. Am I going to be temperature testing every day? Am I going to have the clients, employees, fill out a form that says they temperature tested themselves at home? There's, the laundry list of questions that they suggest that you should ask employees regularly. Have they been exposed to anyone that has the disease? Have they been coughing? Do they feel ill? And in addition to, like I said, trying to gather all of that information, a lot of wellness companies are coming up with methods to help you do that. Whether it is they come out and do the temperature testing for you, or a lot of the larger ones have come up with apps that your employees can fill out, and that, basically gather the information that you feel will keep you in compliance with making sure you have a safe workplace. Unfortunately, that might create an entirely different exposure for you, which is the gathering of and storing of large amounts of medical information about your employees. That creates a whole different world of exposure. And so if you're contemplating doing any of those applications, or gathering the information, even in paper, in writing, it's very important for you to weigh all of the exposures that you're dealing with before you make a decision. Whatever decision you make is great, just make an informed decision. Then it becomes important to regularly monitor the new federal, state, and local guidance that comes out. We do have a template. It is a sample template return to work plan that we can provide. So at the end of this, I have provided my contact information, and if anyone were looking for a sample return to work plan, we'd be happy to supply that to you. Criminal activity. It's an opportunity. All of this, with all the work from home, has created a vast, enormous opening for cybercrime. And so the increase in phishing emails, and extortion threats, spying it's like a tsunami. Our filters that we have in our company, I would have said to you in the last 6 months that not one phishing email got through our filter into my inbox in the 6 months prior to COVID. Since COVID, I would tell you that I probably end up receiving in my inbox somewhere between 4 to 5 a week. The sheer volume of the attack is just straining detection and protection systems that everyone has, and creates an enormous additional challenge for your businesses. You have two sets of potential issues. You have issues to your own business, and then you have issues that are related to liabilities because you might expose your customers' systems. People might use your employees to get into some of your customers' systems. So, those exposures are real, and right now at a great increase. Working from home creates a lot of fissures in your protection, just because there is now an additional opportunity for these criminals to get into your system. People are sharing equipment at home. People are using personal equipment at home. And they're using VPNs, and those vulnerabilities are sought out, found, and targeted. And then again, because as I mentioned, a lot of people are home with their children. And that's one of the realities of business today. People are working from home, and you have families where 2 people are working, the kids are at home, there's no school, there's no daycare. And so they're working unusual hours. And as a result of that, that 24/7 means that we're less likely to update and put in patches as they receive. So, we're all trained to click. Untraining is really hard, but failure to untrain that desire to click can be very expensive. So, the key to all of that is communicating constantly with your employees and making sure that they're aware of what those liabilities potentially can be. So this isn't necessarily related to the rest of the previous or my topic today in full, in the sense that this isn't an employment related issue, but poor economic conditions increase the likelihood of a loss. And we see this, over the years, we've always seen this in insurance. When there's an economic downturn, claims increase, particularly professional liability claims. And we're starting to see a little bit of an increase in that area. And what is it? Well, we see failure to meet contract requirements, or this does not perform as warranted, or it doesn't do what we thought it was going to do or you said it was going to do. And in reality, it's a guise or negotiation tactic to slow down payments or to not pay for services. And so obviously, as a CSIA member, you have access to best practices. And best practices in any area like this is always that documentation is critical, and getting agreement and sign off as you go through a project is also critical. We know that these are claims from customers, and often they're claims from customers that you don't just do one project with, and often they're worked out. But because the client alleges that there is a negligence in your professional services, and because ultimately they can result in a professional liability claim, we think that it's really important that you consider some of your insurance provisions when you start negotiating with a client who is alleging these type of allegations. Insurance policies have provisions that state that if you fail to report a claim promptly, or if you prejudice their rights, their defense in a negotiation, that those are reasons why coverage could be denied later on. So if you have a situation like this, it starts to, we're not paying you because, just similar, typically that's how they start. Not just to drive out there and negotiate with the client without considering both legal and the insurance aspects of your program, and to make sure that you are in contact with your professionals so that you do not prejudice any insurance coverage that might be available to you should that claim become a full-blown professional liability claim. So at this time, I would be more than happy to answer any questions that anyone has. I would say that if you have a state-specific workers' compensation claim, I would be more than happy to take an email and provide a response if I cannot answer it off the top of my head during this program. There are 50 states and I don't have them all memorized. So.
All right, thank you. So for Q&A, it looks like we have one here. How do you get WC credit for workers paid but not working, or working at a less hazardous class? What do we need to do specifically? Wait until renewal audit?
So if it's a significant number, what we're seeing, well, let me backtrack for a second. If you've had a payroll decrease, and it's a significant payroll decrease during this period of time, most insurance companies are willing to work with you midterm on your insurance program and adjust your pricing midterm. So that's just a general comment. Most states have come out with provisions that have forbidden insurance carriers from issuing notice of cancellation for non-payment for a period of, in some states, it's 60 days. Those provisions, those executive orders, those insurance department orders are in place in most states until June 15th or June 30th. In some states, it runs into July. So if you've had a situation where you can't pay your premium installments or something of that sort, and you have the ability and the right to reach out to your insurance carrier to basically to prevent them from canceling the coverage. But in addition to that, most insurance carriers are working with clients if there has been a change in exposure to reduce premiums if needed. The other way of doing it is to wait till the audit. And so in the situation where you have either a reduction in payroll, or you want to isolate people that you're paying that aren't working, then you would take that payroll information and with whatever payroll system you have, you should be able to categorize them differently from a workers' compensation standpoint for the time period that you're paying for them, you're paying them and they're not working. And so then it would be removed from your audit payroll.
Okay, thank you, Gloria. We have another one here, and I want to encourage everybody to go ahead and ask questions now. We did end a little early to fill some time for questions, so feel free to put those in there and we can get to as many as we can. The next one, Gloria, is does business interruption insurance cover shutdowns and or revenue drops due to COVID?
This is the most explosive insurance question in the country right now, truly. If I were to do the textbook response to the question, business income coverage is written to cover losses that basically business loss, revenue loss that results from physical damage at a covered location from a covered cause of loss, which typically it's the world of I had a fire, the building's burnt down, I can't go in, I can't build panels, I have a revenue loss. Or it's a windstorm and the building is damaged and I can't get into the building and I have a revenue claim. Now, I said the textbook answer. So if it's just a shutdown, it's just an economic slowdown, the chances are unlikely that that you're going to have coverage under business interruption. If you have COVID present at your location, then that drives an entirely different set of possibilities. And from state to state, legally, the question of whether that constitutes physical damage, in some states it might, and in some states it might not. And then you have the loss and expense associated with just cleanup and things of that sort. So the answer to the question would be every set of circumstances is different. And if you feel that you potentially have a compensable business interruption, we don't use that, technically use that term anymore, but everyone's using it now, a business income loss or an extra expense claim related to COVID, I would encourage and suggest that you file the loss and let the insurance company do an investigation and respond to your claim individually. There are, I will tell you, right now there are several federal actions. There is the insurance industry's position, that's the insurance company's position, is that the business income loss for just 2 months exceeds the capital that the industry has. And so they think they've asserted that the same way we have TRIA, where we have a government backstop, there ought to be a PRIA, which is the pandemic government backstop, so that the insurance companies would offer that insurance, and if the loss became too big, the government would be a backstop for it. So there is PRIA litigation out there, and then there are a number of states that are considering legislation to order the payment of business income claims for their constituents. So it's volatile.
Okay, understood, Gloria. So if we have any more, I encourage you guys to please put some questions in there if you have any. We'll take a minute if just to see if any more come in.
And as I mentioned, there's my contact information. You can contact myself or Jeff and request that sample return to work plan. We do have that template available and it's quite helpful.
Thank you, Gloria. Well, thank you for the presentation and thanks for being here and not in Tuscany, Italy. No, you'd probably rather be there. Gloria had a trip planned for this week.
Yes. It's far more fun.
So I don't see any more. So we're gonna take that as it there.
Okay.
So I want to thank Gloria and thank all of those attending on behalf of CSIA. We hope you found the webinar informational. When you close out of the webinar, there's going to be a link that's going to pop up. If you could just take a moment to share some thoughts or maybe some ideas for a future webinar, we would greatly appreciate it. We'd also like to remind you that a recording of this webinar will be available shortly, probably in the coming days. And it will be posted to the ControlSys webpage under the webinar archive section. If you don't know where that is, you can always search it in the toolbar on the top right. It's going to be under webinars on the top red little line there. Oh, I thought I saw another one come in. I did not. So that will be sent out, and just look over there if you see a webinar that you may have missed. We have plenty of them in there. With that, I believe that is our program for today. Thank you again, Gloria, and thanks all those attending.
Thank you.
All right, bye now.